The English legal system is a particularly unique system. Unlike most countries in the world, this country doesn't have a written constitution, that is, a document which sets out the fundamental things that govern the running of the state. And that has implications. Where a country has a written constitution, major things such as the functions of the courts are laid out in a document which has binding legal force and cannot be overridden. In this country, the tradition has essentially been one of continuity. There's been no single event which has changed the course of history in a radical way, in the way that other countries have experienced. So, for example, this country hasn't lost a war and had to rebuild following conquest. It hasn't had a revolution. It hasn't gained independence. And so there's been no impetus for the development of any set of fundamental principles. So the legal system, as part of this, has tended to grow up in a fairly unpatterned way. In place of a written constitution, this country essentially has the principle of parliamentary sovereignty. That is, that the ultimate law-making body is Parliament. So the English legal system then has not developed on a blueprint. It's developed in a continuous and incremental way. There have been some major changes along the way, but essentially it's been one of gradual rather than radical change. Why do we need to consider questions to do with the system when we're looking at rules? Well, any rule-based system has to have mechanisms for the way in which those rules operate. Rules don't exist in isolation. We have to, first of all, identify where they come from. And there's an important distinction to be drawn between rules which are laws and other types of rule which are not law. Because it's important that we know where we get laws from, what they look like, and what effect they have. One of those effects is that they come into a very formal system, and under our system, the adjudication of disputes about the law is the province of the courts. So the fact of something being a law means that any disputes about it will be resolved by the courts rather than by other means. Because also we need to think about how matters are processed, we have not only rules of substance, for example, the rules which tell us what a criminal offence is, or what a tort is, or what a company needs to do to get itself registered, but also we need procedural rules in order to help us process those rules through the court system. So rules don't exist in isolation, they exist within a framework. And we need rules for dealing with conflicts as they arise within that framework. So an important feature of the legal system is that it operates in a set of hierarchies. As we'll see, the courts are in a hierarchy. This enables decisions to be processed through in a way which tells us which decisions are the most authoritative, which we need to take particular notice of, and which are of lesser importance. Equally, we need to have mechanisms for adjudicating between competing rules. If we have, for example, a statute which conflicts with a rule of common law, which prevails? We need to have rules to deal with that, and we do, because the sources of law are based in a hierarchical system also. So in that example, statute would prevail over a rule of common law.